atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Northern Kentucky University political scientist Michael Baranowski. I'm joined today by my conservative counterpart, Cleveland area attorney and defender of freedom, Jay Carson.
Hey, good morning, Mike.
Hey, Jay, how are you this morning?
You know, I'm a big fan of American Revolution and early Federalist history. And I found this that sort of sums up the week. Well, I shouldn't say the week I've had, because other people have had much worse weeks. We'll talk about that. But the way they put things back in those days, his unexampled perseverance and fidelity under accumulated hardships and wrongs have excited the astonishment and applause of strangers.
Wow.
Which is sort of the colonial way of like, I can't believe he puts up with this.
If you have had a week that excited the astonishment and applause of strangers, I'd say that's a good week. As you point out, not a good week for everyone, certainly. And it has been good, bad, or indifferent. It has certainly been an insanely busy week politically. And that's mainly because the Supreme Court has announced, I would say, more important decisions in a shorter period than I can ever recall. And in looking through all those decisions, I realized that there was almost no way we would be able to do justice to them, cover them to the extent that we should. And so we will get through what we can, but what we aren't able to cover, we'll certainly get to next week's show when Nate and I will cover them, and also the other.
It'll still be the law next week.
Exactly.
Yeah.
Exactly. So, all right. One other thing before we get started, I want to thank Alex, who's a new Patreon trial member. That's a thing you can do. So if you're interested in that, check it out. All right. Well, Jay, everyone knows what we're going to start with. It was painful. Yet I don't normally watch presidential debates because there's almost no real substance, and they, I think, rarely tell us anything we don't already know about the candidates. But this time felt to me like something I needed to watch because, of course, the age issue, an enormous burden for Biden. Even before the debate, large majorities of Americans, including Democrats, consistently telling pollsters that they think Biden is too old to run again. And it's clear that the Biden camp thought that a strong debate performance could probably not put those concerns to rest entirely, but at least to allow them to make, I would say, a plausible case that Joe Biden wasn't the doddering old man that a lot of people think he's become or claim he's become. And it's also fairly clear that plan backfired spectacularly, right? And it set off, I'd say, a near panic in some Democratic circles. There have been multiple calls for Biden to abandon his bid for a second term, including the New York Times editorial board, among many, many others. Although to this point, Joe Biden seems defiant that he will continue on in a rally in North Carolina the day after, where he looked like a different guy, though, of course, 20 minutes with, I believe, a teleprompter in front of an adoring crowd is a whole different thing than 90 minutes without any notes or anything like that. But I'll just say I didn't watch it live, and I'm glad, because there were moments where I just actually had to pause because it was just hard to watch that sort of thing. And I would think that anyone who would have any amount of human sympathy would look at Joe Biden in that moment, especially the first 20 minutes or so of the debate, and just think like, oh my gosh, this poor man should not be up here. But anyway, that's my initial take. Jay, what did you take away from the debate?
So I'm not going to get into sort of what you just done, because I think you've said it, and I think everything that people saw sort of speaks for itself. What I will say, and what I think is actually the more interesting question, right, is that who thought this plan was going to work, and how could, and again, I'm looking at this in a couple different ways, right? As someone who's worked in the political arena, that this is such gross political malpractice.
See, I don't think so. I know what you're saying.
Of the 16 advisors who met with him for a week, all last week, were any of them, were they saying, you got this, Joe? That's just what I think is astounding to me. And And also the other piece of it, which again is not directly related to Joe Biden, but more, I guess, the administration and other Democrats, is that last week we were being told that if you see Biden looking old, it's because it's cheap fakes, which I still don't know exactly what the hell that means. And I think it's a made up term to confuse old people who are easily confused. But yeah, we were being lectured on, oh, you can't believe what you see. He's sharp. And if you meet him behind closed doors, gosh, we have to tell him to slow down. I guess that's my sense. And like, that's where we were a week ago. And where we are now is a lot of those same people are saying, do we have another alternative?
Well,
where were they last week?
I think you're wrong about all of that. And I'll tell you why I think you're wrong about all of that. I assume that in your long and distinguished career as an attorney, you have had clients who just were incredibly difficult to deal with, but you are their client. And if they say, no, this is the path I want to go down, even if privately you might say, my gosh, this is an incredibly bad idea. In the end, you do what they want, or you leave, or you don't represent them anymore. And I think it's a very similar thing with Joe Biden. Joe Biden, I believe, fervently believes in his heart that he can do this, and he can do this for 4 years from now. He's up for this job, and so in the end, even if his aides are telling him, "Listen, is this such a good idea?" In the end, he gets to make that decision, and more than that, I think it's very difficult for people close to the president to not be some sort of yes men in that sort of thing. We've seen that with Donald Trump, right? How did the Republican establishment allow Donald Trump to become president, this awful, sleazy, lying, horrific guy? Well, it's because the nature of politics makes it almost certain that you're going to have a bunch of enablers and sycophants and yes men that are close to the top. And so this, to me, is not political malpractice. This is just a sad, but and maybe all too common political story.
Well, I mean, that makes sense to some extent for the people directly around the president, right, and the administration. If you want to make the argument, hey, look, he's the boss, and we got to do what we're told. Fair enough. And I think there could be some advisors who were saying, well, hey, look, let's try to make the best of the bad situation, get them as prepared as possible. But there's also a whole lot of folks who aren't really in the administration, who have been in the media, other just sort of, pundits, cheerleaders, et cetera, who didn't have that same relationship. And even so, the 25th Amendment's there for a reason. And I think you're getting, someone texted me that, would someone, invoke the 25th Amendment during a commercial break? And again, Jon Stewart was talking 25th Amendment. This isn't far right-wing propaganda kind of stuff. But I think there's a point where you say, okay, I'm loyal to the boss, I'm a team player. But there's also a point where, in good conscience, you can't go forward with what's happening.
You are expecting a level of political courage that it just does not exist in this universe, Jay. I mean, we've seen it on the Republican side, right? But it doesn't. And so saying that, I mean, my gosh, you're sounding like some sort of progressive utopian saying, if only we could just change how people are, then things would be better. Well, that's not come on, Jay, be your pragmatic Machiavellian sort of.
I will be my pragmatic Machiavellian self and point out, if I'm making that argument, look, like if you're making this argument to a client, right? And you say, listen, if you take the stand, or if you don't settle this case, if you go forward, here's the questions they're going to ask you in the deposition. Here's the documents they're going to ask you to produce. Are you ready to do that? Let's do that. Let's do a run through. See how it goes.
And presumably they did that. We know he did debate prep, but pretty clearly, and I think it was just a case of, well, we'll keep our fingers crossed. We'll see how it goes. And maybe there were some people, and wouldn't surprise me, saying, you know what, this is going to be a disaster, but maybe what he needs is an unmitigated disaster to get him and Jill and the people around him convinced enough to push him hard enough to get out. And sometimes that's what it takes.
That could be too. Because I've seen situations like that. where you just have to let someone go ahead and fail and be wrong.
Exactly.
And then you can come back and, more or less say, I told you so. I'm saying there could be some of that, but it's, I guess that's my point is, did anyone think this was really going to work out well?
And all that matters is that Joe Biden thought that.
Listen, yeah. I right. I mean, it's going to be found out. I guess was the point.
Yeah. Well, I mean, the problem is when you have an incumbent president who is determined to run again, it is really, really difficult to change that trajectory. And even now, it's going to be, I think, incredibly difficult. I think what's going to happen, I hope I'm wrong about this, I think what's going to happen is the Biden folks are already saying, well, it's just it's going to be maybe a short post-debate bump for Donald Trump. But if you take a look on the facts, on the substance, I did better than Donald Trump did. I mean, it's already been some of the spin. And so I think it's going to be, he's going to hang on to the point where saying, well, something could happen possibly. And that's going to be a disaster. So I think that they're also going to make the argument that, just like how Trump's lying, criminality, sleaziness are kind of baked in already, they're going to say, well, most people already felt that the age thing was kind of baked in with Biden. So this isn't going to change a whole lot. And I think that's the sort of logic that's going to result in an almost certain Donald Trump win if Joe Biden is the nominee. And so the question now for Democrats is, well, do you want to almost certainly lose with Joe Biden as your nominee, or do you want to cause a whole lot of short-term commotion and pain and rancor within the party and have at least a somewhat better chance of winning? And if democracy is at stake, if Donald Trump is the existential threat that the Joe Biden, the New York Times, and everyone else says he is, then I think you have to throw loyalty to Joe Biden and his distinguished, half-century long political service out the window and say, hey, democracy is at stake. We just can't, we can't just let this go. And I hope that's going to happen, but I don't think that's going to happen.
But didn't what I'm saying is, didn't they know that a year ago or 2 years ago or 4 years ago?
Well, sure. But again, you're asking for a level of political courage that we haven't seen on either side of the aisle, that our politics actively discourages. So, of course.
Well, I wouldn't say necessarily courage, maybe just foresight.
Well, it's not foresight because you have to go against.
Here's the thing.
The difference is that you have to go against the president. You have to make a case. You have to be the person first out there saying the president should not run again because he is not mentally capable of doing that. That takes an incredible amount of courage. Given that,
when you had a whole bunch of Republicans who ran against Trump on that
but most of them did, platform. Right? But I mean, and see what happened to them. So lesson learned.
Yeah.
Right?
Well, no, I'm saying, but the other thing that happened to them is, there were actual primaries and people voted, and they lost.
Right. So there's your courage for you. So it didn't work, and my career was destroyed. And so I think Democrats would look at that and say, well, okay, I'm not going to do that dumb thing again because, hey, it's, of course, personal ambition before country. We all know that's the rule in politics these days.
I guess my point is the personal ambition is perhaps short-sighted.
Yeah.
A lot of these folks should be looking at, or could have been looking at 4 years ago, 3.5 years ago. Listen, this is going to be, as he promised, a caretaker president, return to normalcy, and he's just going to be a one-term bridge president and all that. But they never came up with a credible plan B, even though they knew that these issues were there, and just denied them for years and years and years. I think that the fact that there is a panic now also says a little bit about bubbles, right? And I mean, Republicans have been saying this for years, and then all of a sudden, the host of CNN and MSNBC are saying, "Well, no, we got to throw him over the side." I guess that's just my sense is something changed.
Well, maybe
when this
not,
became apparent
I think
everybody watching, and
I think you're assuming. I think you're making a lot of assumptions that might not actually be correct. There's something that Ezra Klein said in the wake of the debate, something to the effect of Joe Biden can do the job of the presidency, but not perform the job of the presidency. And that might not be right, but it's not a ridiculous argument. And I think that's what a lot of folks have felt. I felt that for a number of years, saying, and also if you look back in 2020, Joe Biden looked okay. I mean, it seemed like okay, and so.
Well, he also was very limited in his
sure,
appearances.
But again, I think you are assuming a level of foresight and courage. Just you're assuming these sort of superhuman qualities among people on the left that we don't see on the left, on the right, or anywhere else. Maybe if you were one of his advisors, you would have done that. But I'd like to think that I would have. But that's just not how politics works.
So let me just say this in terms of because my every time Ezra Klein says something, I feel I've got to. He can do the job of president, but he can't perform as president. I mean, I guess Hillary Clinton back in the day ran a commercial of the when the phone rings at 3 a.m. Who do you want answering it? And this is the phone rings at 3 p.m. Who would you want answering? But imagine the phone rings and Mr. President, Chinese warships are steaming towards Taiwan. They've launched rocket attacks. Please advise. Right? Did your heart just stop for a second?
No, because I mean,
no, it's fine.
No.
He's got it.
I mean, I'm sorry if my response isn't the one you want, but it's my response because I think what happens in those situations is there are consultations. It's not like the president's carrying around his finger on the button all the time. So yeah, let's launch, baby.
Mr. President, we've got Premier Xi on the phone. What are you going to tell him?
I think
he wants to talk to you.
I'm not.
He wants to know. He wants to know. Are you going to attack Taiwan? If you do, he's going to say that's a declaration of war against China. He's on the line now, Mr. President.
This is not a reality show or some sort. This is not how these things work.
No,
I'm not. No,
just much a reality show.
Let me be clear. It is possible that there are instances like that. I'm not arguing that, right? And of course, I do not want someone who seems like has Joe Biden's issues being very quick, not being very quick in those situations. Absolutely. What I'm saying is that is not vanishingly, but those things are very rare. And you also have to weigh that, of course, against what you will be getting with Donald Trump. And so to me, it's still a question of, well, there are at this point 3 options, right, for Democrats. There's stick with Joe Biden to the bitter end. There's, vote for Donald Trump because Joe Biden can't do the job. And then there's try to replace Joe Biden with someone else, right? And one of those options is completely unacceptable. And that is, of course, the vote for Donald Trump option. And so we're left with 2 not so great options. But I would argue that even a diminished if Joe Biden ends up being the nominee and I were in a state that mattered for my vote, I would absolutely vote for him and just think, oh my God, this is better than the other guy, but geez, it's bad for very different reasons. But I would rather be able to vote for Gretchen Whitmer or Josh Shapiro or Andy Bashir or someone like that, which is, how I hope it comes out, but we'll have to see.
Again, but I just you believe that he is fit to be commander in chief, given the
I believe,
again, Mr. President, our satellites have just detected a tactical nuke was detonated over Kyiv.
I don't know. It's a fair question to raise. I have deep concerns about that sort of thing.
Mr. President, we've just confirmed the Russians.
Jay, I get it. Watched a lot of movies. You could run through all these scenarios. I understand what you're saying. Giving me 5 more scenarios is not going to change how I respond to it.
Taiwan? No, it'll never happen.
Right. I'm just saying that, yes, I understand what you're saying. And I acknowledge, yes, that is something I have a concern about. But I also know that it's not like some TV reality show where he's stuck in a box by himself and has to make these decisions all the time. In an instant's notice, he has people. And so I'm saying you're setting up not a false situation, but an exaggeration. That brings back
to then who is the president?
Well, yeah, exactly.
Yeah.
And I am saying that I would rather, if it comes to it, I would rather have a situation where decisions are made by Joe Biden and the team around him than by Donald Trump. Absolutely.
Right. All right. Trust the generals.
Well, if it's
the Democrats are now going to rely on.
If it's
do what the generals say.
Jay, if it's trust the generals or trust Donald Trump, yes, I trust the generals. Absolutely. So anyway, before we move on, any other thoughts on, my sense is that even though there's this talk now about, replacing Biden, I don't think it's going to happen. And I think also the fact that there's such a push for it, like I said, the New York Times editorial board came out, the big thing, that essentially it because it won't happen, it's like the worst case scenario because it weakens him tremendously, right? Because now the other side can just say, hey, look at his own side is just saying this guy is not fit. So basically, it essentially is going to almost ensure that Donald Trump will in fact be reelected. That's my prediction for how this is going to play out. And I wanted to get yours.
I think that's probably right, although I don't know. I wouldn't put it past Democrats to try to replace him.
Oh yes, plenty will.
Right? I mean, they would at some point they'd have to say, "Geez, if again there are people who would probably truly believe that Donald Trump's an existential threat, and there's probably other folks who just really like to be president." So, yeah.
Well, we will see. I think the next week,
easy road to do it.
Yeah, to me, the next week is going to be really the next week or two, because that's when we'll start to see the polling numbers. And if we wait out a week or 2 or 3 weeks, it's going to be harder to argue if they do what I think they're going to do, that this is just a short-term kind of Trump bump or Biden slump sort of thing. But by that point, it might be too late. But we'll see. This just looks pretty tragic from my standpoint.
So I do want to say one thing, sort of magnanimous. I thought the CNN host did really well. I think the questions were pretty fair. I can take issue with one or two of them where I think there were some assumptions embedded that might not have deserved to be embedded in the questions. But generally, I thought they handled what was going on pretty well and pretty professionally.
Yeah,
I know what your thoughts are on that. But
no, I didn't have any problems with it. It seemed. I mean, to the extent that I could actually focus on anything. Now, to be fair, I feel like Biden got better as the evening went on, which would be the opposite of what one would expect from somebody who is, has age-related issues, because you would expect them to tire and get worse. So, but again, my ideal for the debate would have been that Joe Biden stumbled so bad, much worse than he looked on Thursday night. I mean, I was saying that back at the State of the Union. I was saying,
how could he have stumbled? I mean, aside from like literally falling on his face walking out there.
I think your bias is showing through here, because, like I said, when I watched the whole thing, toward the end, he got better. He wasn't great. He was never great, and certainly there were plenty of those moments. But it's not like he didn't know where he was or any. I mean, for the whole time. So I was hoping for something, and this is horrible, that was just
Biden 24. He knows where he is some of the time.
No, but what I'm saying is that I was hoping, for the sake of the country, that his performance was going to be much worse than what it was, enough so that no one would be able to plausibly say, well,
force a replacement.
Exactly.
Well, I think you may have gotten that.
I don't.
We'll see.
I hope, but we'll see. Yeah. All right. Let's move on to something very different. As I said, it was a big week for the Supreme Court. So many cases. And Jay,
So this is a big one, and I get to take a victory lap here.
There you go. I know we've talked about Chevron so often for so many years now on the show that there was no way we couldn't talk about this right after the debate. So go ahead.
Yes. So the Supreme Court just yesterday issued a decision in Loper Bright Enterprises versus Raimondo. It was combined with another case, Relentless et al. Versus Department of Commerce, which overruled the 1984 case of Chevron versus Natural Resources Defense Council. The uptake of this, look what's happening to me. The result is that courts will no longer be required to apply what's called Chevron deference to agency decisions interpreting statutes. The way this worked, the Chevron doctrine, was that, listen, if there was some ambiguity within a statute, then the agency could interpret it sort of using its own interpretation, its internal guidance, with the theory being they have the expertise in the statute, in the subject matter. And if they made that determination, courts would essentially defer, meaning adopt that determination. Conservatives have for a long time argued against this as an expansion of regulatory power. And this is a big turning point. Again, it's not probably as sexy as a lot of Supreme Court cases that you're going to hear about or ones you might hear about on Monday. But I think in the long term, it's more meaningful. So I'll get into the quick facts of the case, as you might expect, involve fishing. So, and there was, Mike, I wish I could find it now. There was a great quote I used in an amicus brief in a similar case. But Ernest Hemingway said, "There's nothing worse than, the only thing worse than like someone looking over your shoulder when you're with a woman is someone looking over your shoulder when you're fishing." And that's what it comes down to. There was the MSA, it was called, which was I believe it was Mr. Magnuson, Senator Magnuson, the Magnuson-Stevens Fishery Conservation and Management Act, which required the Department of Commerce to provide a mechanism for specifying annual catch limits, including those plans may prohibit, limit, condition, or require the use of specified types and quantities of fishing gear, fishing vessels, equipment, reserve a portion of the allowable biological catch of the fishery for use in scientific research, and prescribe such other measures
that sounds dull.
Appropriate for the conservation and management of the fishery, which all sounds, pretty sensible. Now, one of another piece is that the plan can also require that one or more observers be carried on board domestic vessels for the purpose of collecting data necessarily for the conservation and management of the fishery. So what happened is the Department of Commerce interpreted this, and I won't get into all the different types of fishing vessels and
That's probably
who
good,
has to be on there, but as it's almost a Third Amendment case, requiring vessel owners to essentially pay for federal officers to stay on their boats. They had to feed them, host them, sail them around while they fished. If they couldn't find federal officers, they had to contract with a government-approved third-party observer. The department then said, well, this is clearly within its Chevron deference, that it can interpret the statute broadly to allow this sort of requirement. The court disagreed in I would say that the majority agreed in no uncertain terms. It was a 6-3 decision, saying that look, the interpretations and opinions of relevant things it's important, but when it comes down to deciding the law, there is a separation of powers question, and it goes to Congress, not the executive branch, to make these decisions, and thus Chevron deference violates the requirements of the Administrative Procedures Act. That was a longer intro than what you needed. But again, I just wanted to talk about the fishing and stuff.
Sure.
So, Mike, what are your thoughts? Now, you sent an interesting text after reading the opinion, so I wanted to get your thoughts.
Yeah, I've been I wouldn't say a fan of Chevron. Fan was kind of a little strong, but I've been a supporter of Chevron deference. I'm sure there are fans, but a supporter for a long time. And so in reading through both the majority opinion and the dissent, I really thought about Chevron in a more extensive, comprehensive way than I had in quite a long period of time. And here's where I came down. I believe that it is important that the courts give considerable weight to interpretations of agency experts when it comes to things that touch on agency expertise. And I don't expect you would disagree with that.
Right. No, and I think that's exactly right.
And so that's been how courts have operated for, well, forever, basically. But that changed to a formal rule about this deference thing in the Chevron case, which was in the, I believe in, I want to say the early 80s or something. Something
1984.
1984. And so,
which was otherwise a pretty good year, but
you know, but here's my issue, I guess. I think I might have actually been, I don't think I'm wrong about giving weight to administrative agencies in areas of their expertise, but I think I might have been wrong about automatically deferring to them on matters of statutory interpretation, because I think the majority made a worthwhile point saying that, well, what's at issue here? What's at issue is, how do we read this law? What does this law mean? Now, who are the people who are expert at that? Well, it's not necessarily the career employees at the EPA or the fisheries agency or something like that. It's going to be Congress and the courts. That's their job.
Who should be the judges and juries of our society?
Exactly.
Right?
And
judges and juries.
And so, I think Chevron, one of the big advantages of Chevron is it makes life easier for almost everyone. It makes life easier for the courts. They can just say, hey, we don't have to think about this issue. We can just defer, essentially, as long as it's not outside of the clear meaning of the law. It makes life easier for administrative agencies. It makes life even easier for Congress, because they can write these sort of broad things and just say the agencies can figure it out. But the issue,
actually, I would say that's the biggest problem of Chevron. But go ahead.
But the issue isn't about what's the most efficient and what makes life the easiest. It's about who gets to say what the law means in the end. And so that's why in the end I came down, I read Justice Kagan's dissent, I believe, where she said, it's the courts now that will wield the power now when Congress has left an area of interpretive discretion. A rule of judicial humility gives way to a rule of judicial hubris. And I felt that, in my gut. But then I thought, well, wait a second, though. What's the job of the courts? Should we be having these administrative agencies doing the job of Congress and the courts? And in the end, I said, well, no, I don't think so. So I'm for giving weight to agencies, but not for automatic Chevron deference. And so I believe I've changed my position on this. And, I'll also point out that Congress can.
Welcome back to the fight.
But Congress can write legislation and has written legislation, plenty of legislation, that clearly gives agencies the authority to sort of fill in the blanks. And let me give you an example. In the Clean Air Act, there's a provision that says the administrator may distinguish among classes, types, and sizes within categories for news sources for various standards. And so right there, that's Congress saying, yes, we're giving you this sort of broad authority within these lines. And so Congress has to be a little clearer about when it wants the agency to have that sort of deference, if you will, and when it doesn't. And Congress can and should be doing that in the first place. And so I think this is a decision that makes life harder for agencies in the short run, but should make for a more responsible Congress, I hope, at least a push in that direction, and actually a system that honors the rule of law and who gets to determine what the law means in the long run. So even though this works against, I think, my short-term policy interests, I think this is the right decision in the long term.
Yeah. Wow. Well, I'm glad to see that there's a convert here. And who agrees with you, Mike, would be a former Chief Justice John Marshall, who wrote in 1803 that it is emphatically the province of the judiciary to say what the law is. And that's, really one of our fundamental principles of our government. And it's reaffirmed here. And I think you're right. There's still, I think, plenty of room for Congress to grant authority for agencies to, sort of set their own course to some extent and rely on their own expertise. But what we've seen is the abuse of Chevron. I think that goes to show sort of, one, that power corrupts, right? If you give them an inch, they'll take a mile. Where you did have agencies sort of engaging in essentially legal interpretations, not making technical decisions, right? Of the right. The particulate amount should be this many parts per million as opposed to that many parts per million based on the scientific expertise of the agency. but rather saying the statute empowers us to do X, Y, and Z. And that's a legal decision, not a technical administrative decision. So, yeah, I think this is, and it's so often, like, you and I bemoan what you just said, that Congress doesn't write serious statutes anymore. They do just sort of hand off to the administration, and there's a danger in that. And actually, there's an amicus brief filed. I don't know if it was in this case or another case, but scholars have done research on this and interviewed the folks who actually draft statutes, and they said, well, yeah, we drafted to try to give the most ambiguity that we can, so that the agency has the most power to interpret it, and therefore, courts to defer to it. And I think so often people misunderstand it, what Chevron deference meant in terms of deference in common parlance can sort of mean all sort of, give you a little extra weight, right?
Yeah, no, that doesn't mean,
what it means here
no,
is
it just
no,
means,
I will,
is this a ridiculous reading? Yeah.
I'm deferring and canting the whole, it's maybe, if we had called it Chevron abdication, this wouldn't have taken so long.
Well, and, I guess the term, I would say I would not paint it quite that broadly, because I think that, still, even under Chevron, when an agency did something that was clearly outside the scope of its authority,
there was a.
But again, to me, the idea that the court should not be allowed to exercise their discretion, independent judgment about what the law means. And that's how I reformulated it. When I reformulated it that way, it's like, well, and I get why people on the left are upset about this and think it's the worst thing in the world. And yeah, I mean, when you have a situation in which the Supreme Court has a majority that's a strong majority that's conservative, and you have administrative agencies that are more left than right of center, then yeah, that's going to look bad. But it's not that difficult to envision a world in which these administrative agencies all of a sudden become a little more right of center. That was the case in the 80s. I mean, back in the 80s, there were more conservatives who were like, yeah, the Chevron thing's good because we want the Reagan EPA and these other agencies to be able to have, more carte blanche to do what they want, to deregulate and all that. And so it can work. It can cut both ways, is my point.
Yeah.
So,
yeah.
But yeah,
I agree structurally, if you want a representative government.
Yeah.
Yeah. But so I would also note, I mean, Chevron, this isn't necessarily a surprise.
No, not at all.
It's one of those, I don't know how you say it. It's sort of, everybody thought it would happen, but on the one hand, you are still sort of, wow, it actually did happen. But Chevron had been criticized from all angles for many years amongst judges, amongst professors. There were various state Chevron Junior sort of doctrines about interpreting state administrative agencies interpreting legislation. Ohio jettisoned that last year. So there had been this growing tide of criticism and other pieces chipping away at Chevron, either tightening it up or, for example, the major questions doctrine, which is sort of Chevron adjacent, right? That was used. So it's not that this was out of the blue, but yeah, it still is a big deal.
Yeah, and to me, I guess on a more personal note, it's a reminder that once we've formed opinions on something for whatever reason, oftentimes it can be challenging to really rethink through them. Because that's just not, life is busy. We have things going on and so forth. And so the only reason
You've got time to think about, regulatory deference. Yeah.
And I think that's true, not just on this, but on a whole host of issues, is that we just say, well, no, this is my position, and I'm just going to cherry pick the arguments that I believe support that. And I think that's just as true. That's very bipartisan. And I feel thankful that I am fortunate enough to be in a position where sometimes, at least, I'm able to make the time and the space to sort of pull back and think through these. And sometimes I just find myself saying, and maybe more often than not, it's like, nope, I was right about that one. But every once in a while when I do that, I found myself saying, oh, okay, well, maybe not so much. And this was one of these instances. So I feel it was not only the
I'm
right
thankful I'm occasionally able to help shepherd that change.
Yeah. One day I will help you do the same thing on your end. I know you're busy.
Look, I've changed my mind on yours.
No.
So I did want to make one last point, which you may or may not agree with, but this goes more deeper in the weeds, right? In the whole sort of regulatory ideology, in that, you know, there was this idea of the progressives, and when I say progressives, I mean the 1910s, 1920s, you know, the original progressives, of this, you know, utopian dream of government by the experts, right? That you would have the very smartest people who would, in a non-political way, apply their expertise to all the various social and technological problems of our country and the world, and that would be great. But the conservative view is always that, you know, we're flawed creatures, and, you know, again, the power corrupts, and absolute power corrupts absolutely. And I think there's something of that runs through here, and that I'm going to just touch the last bit of this and the majority's opinion, where the dissent ends. It's dissent by quoting Chevron and saying judges are not experts in the field. And then the majority responds, that depends, of course, on what the field is. If it is legal interpretations, that has been emphatically the province of the duty of the Judicial Department, again, Marshall, for at least the last 221 years. So I think that is an important now part of, I guess, what's sort of left of conservative ideology, or maybe it's just sort of anti-progressive ideology, is this sense of how much ought we to trust experts. And again, the conservative position counsels skepticism.
Yeah, I think you're right and you're wrong. I think the last thing, I can't let go yet another pushback against expertise just because they're experts. I think that reeks of the sort of mindless populism that sort of brought Donald Trump to power. And I think there's a part that you're right about that I want to agree with, certainly, in that we should trust experts in the area in which they have expertise. And that was the court's opinion. So I feel like you sort of turned that into just don't trust experts. I think, well, if you're going to trust anyone.
No. The point I was trying to make is listen to experts, give them the weight they're due, understand they're still fallible.
Which would include Supreme Court justices and interpretation of the law.
Yeah, absolutely. In their
point that out. Yeah. Okay. All right. Well, you know, we kind of have our pick of other Supreme Court cases to discuss. There's one that will probably maybe take us a little bit longer than the opinion, because it was a one-sentence thing, right? The justices dismissed as improvidently granted, or they dug, I don't know, Moyle versus United States, which concerns an Idaho law, prevents abortions unless necessary to preserve the life of the pregnant woman, with no exception for abortions that are necessary to preserve the woman's health, although Iowa might disagree. There are some factual disagreements here on this, which is maybe part of the reason why it was dug. But so what the order did is the court basically is saying, whoops, we shouldn't have taken this one. We're just not going to now. But it also reinstated the lower court stay of Idaho's, again, near total abortion ban, which now again permits emergency abortions to preserve the life or health of the pregnant woman, at least while the case works its way through the system. And while it was just a very brief procedural order, it didn't feel very procedural, in part because Justices Kagan, Jackson, and Sotomayor dissented, with Justice Jackson actually reading her dissent from the bench, which usually indicates, hey, I've got a real problem with this. And obviously their problem wasn't with the practical result, which means, you know, enjoining or staying this law, but the problem was they felt, well, we should have taken this and ruled on it, or as Justice Jackson said, this months-long catastrophe was completely unnecessary. It directly violates Idaho's law, directly violates federal law, which in our system of government is supreme, and that under this law, we should just have gone ahead and taken it and said, hey, Idaho, you cannot do this, the Supremacy Clause, and so that's why we're not dissenting exactly, but we have a problem with digging this, essentially. So, in other words, the court's three liberals in favor of staying the Idaho law, but felt that the court should not have ungranted cert.
They should have, they shouldn't have just, they should have
ruled on
taken
the
it and
merits.
smacked it down.
So, and Jay, I think this might actually be the first time we've ever discussed the case that the court dismissed as improvidently granted. I'll just use the formal kind of way. What did you think about it?
So, look, I think the court gets it right, and I think the majority gets it right. And you have let this work through the lower courts. You've got the stay in place. There's no reason to undo the stay. So, and I'm hesitant, and I'm also, we haven't talked about this, but I'm hesitant, or my back gets up when I hear about Republicans, calling on the Supreme Court to intervene in the various, Trump prosecutions or something like that. No, the court should not intervene in cases. The court should accept or reject jurisdiction of cases that properly come before it. I think in this case, it was properly dismissed. So, and again, it's sort of, if this was, as I may have said before, there's no way to run a theocracy. It also sort of gives an indication of where the court would be going, I think, on the merits of this.
Yeah, and well,
because what I'm saying is, if the theory of other commentators that this is a corrupt Supreme Court and a corrupt theocratic and so forth, then you would have had 4 votes to take the case and uphold, but you don't, and you're not going to. So,
see, I think the argument would be just the opposite. Well, maybe not just the opposite, but different, saying that, well, of course, I'm trying to sort of channel Ken here on this, but of course the court would go this way because that way they take this issue, to the extent they can, off the table, because otherwise they would have basically had to throw the supremacy clause out the window to support this Idaho law, and that could hurt Donald Trump's chances in the election. Not that I think you see what I'm saying.
So they give up. You would give up the theocracy
in the short run,
and allow unborn babies to be killed just to help Donald Trump.
Well, just in the short run, because it end up saving more in the long run than in the short run.
Yeah. Well, I mean, listeners can judge the logic of that argument for themselves.
I don't necessarily.
I think that the court sort of called it like it saw it on this, and I think it got it right.
But I mean, there's certainly good reason to say, well, wait a second, then why in the heck did they grant cert in the first place? It's a reasonable question to ask, because that's why it is,
and I'm curious as to what those votes were.
Yeah, me too.
Right. I mean, again, the rule is you need 4 to grant cert, and we know who 3 of them are.
Right.
So yeah, who is the 4th? And again, cert decisions aren't typically recorded. You'll get a cert granted, cert denied, and then you'll get a so and so dissents.
I would think it's Clarence Thomas, because he loves just wading into it. It's like, yeah, man, I got a dissent all fired up here, or a decision. I mean, Clarence doesn't care. Man.
That could be part of it. The other thing is sometimes, a case looks one way on the cert petition.
Yeah.
And then maybe another way once you actually dig into it.
Yeah. And there were, as I mentioned, there were apparently some disagreements between the parties as to matters of fact, and the Supreme Court, generally speaking, when there are those kind of disagreements, doesn't like to get involved in that.
Exactly. And that's one thing. If the record looks really clean at first, you'd say, okay, this makes sense that we could take cert on it. If you say, wait a minute, the record is a little more messy, then that's a perfectly good reason to dismiss as improperly granted.
Okay, well, we're going to go a little bit long on this show because I want to get to one more Supreme Court case in the main show before we cover the rest of what we can in the midweek show. And it's because it's an issue, Jay, that I know you care deeply about and have strong opinions about. And I think that we're going to actually have a fair amount of disagreement. And that is another Supreme Court decision in Murphy versus Missouri. And I'll let you sort of give people a background on that.
So Murphy versus Missouri, and it started out as Missouri versus Biden, relates to administrative pressure on social media companies. During COVID, there was a lot of email traffic between the White House and Facebook and Twitter. Most of this comes in relation to Facebook, I believe, where the administration was saying in no uncertain terms, we want these posts downgraded. We don't want these posts up. There are emails from the White House saying, why is this still up? Emails from the White House saying, at the highest levels, take these posts down. And
not take these posts down. I just want to make a factual distinction. There's a difference between saying, and we'll get into this in greater length, but difference between continually, maybe you can use the word hectoring about why are these posts up as opposed to saying, take these posts down. But we'll get into that. Sorry.
Yeah. All right. So a number of states, Missouri first among them, sued on behalf of its citizens, arguing a First Amendment violation that the Biden administration was essentially censoring social media, and in doing so was sort of imposing its own will, keeping people, taking away the right to engage in conversations and read certain information. The court held that the states and the plaintiffs, there were several individual plaintiffs, lacked standing. So they never actually got to the First Amendment issue. The issue being, was there a recognizable harm, right, that had been caused to either the states or some of these individuals? I think the court got it wrong as some of the individuals. I think the arguments on the state standings were always maybe a little stretched, but the importance of the issue, and I think what came out of this, the discovery and the emails and the back and forth, should be pretty alarming. And if anyone's interested, again, I would recommend Judge
Alito's
Judge
dissent
from Louisiana.
Oh, sorry.
Who wrote the district court opinion, Terry Doty.
An awful opinion. Oh my God. Yeah, of course. No, this was, this is one of these instances.
I'm not even saying about, just read the facts as recorded in the record.
But
right?
that this is one of these instances. This is one of these instances where conservative activists throw notions of judicial restraint out the window because they're pissed off at the administration. This is the kind of judicial activism that drives me nuts. And I have a problem with it, whether it's on the left or the right. You could just feel the sparks fly off of Alito's pen or word processor. He just the venom, right? He's worked up, man, in this. And I'm not saying that he's entirely wrong. I have some problems with a real kind of serious jawboning push. Where does jawboning turn into coercion? That's a real question. That's an important question. Yeah. But to just say, well, let's just we'll take the case, even though there's this ridiculous argument about standing. I mean, I think the majority, the 6 justices in the majority, which means that, by the way, not just the court's 3 liberals, but 3 from the conservative bloc, felt that there wasn't standing here. And I think they're right. This crazy notion that, well, okay, these organizations were already censoring some of the stuff, which Facebook and they're allowed to do as private organizations. They were already doing some of this. And, well, did they do more of it because the government asked them, not necessarily asked them to, but asked them questions about their policies? And how do we have any kind of personal injury involved in this that's traceable not to Facebook, but to the government? This was just such an incredible reach. And so I think the majority was absolutely right to say, hey, listen, there's no standing here. And my God, the eye roll I had about we have a right to read stuff from other people. Oh my God, give me a break. People are right to be concerned about government putting so much pressure on private actors that they become de facto government actors. That's a very real concern. But this was not a case for that. This was not a case for the court, and the majority rightly understood that.
So, but let's talk a little bit about the government pressure and the implications of Section 230 is coming up.
So we're not talking about the case anymore.
That's in there. The government says, well,
Are we talking about the policy issue?
Nice social media company you have here.
But hold on. But before I think you would agree that the Supreme Court only handles, or the courts only handle cases and controversies, right?
Sure.
Of course. And so before we get into the policy issue, which I'm happy to talk with you about, and maybe we'll even have a certain amount of agreement on that, we have to decide if this is actually something that's properly in the purview of the court. Because I know you have said many times in the past that you are against judicial activism, against the courts stepping in.
Yeah. Courts are there to decide cases and controversies.
And certainly you do not believe that, well, it's okay if it's something that favors my policy goals.
No. But I would say, and like I said, I think the idea of the states having standing to sue on behalf of citizens is a stretch. There are other individual citizens, though, who had their posts downgraded, removed, pushed back, who I do think that's an infringement on their First Amendment right. They have a right to speak freely. And
Facebook's allowed to do whatever they want.
You can say, look, okay, Facebook can take it down if they want, but for the government pressure, and again, this is a case of the government identifying, hey, we want this guy shut up. That I think is a problem, and I do think that is traceable.
I don't think the case is made very strongly at all that it was traceable, especially because Facebook was doing a lot of this beforehand, and also because in a number of instances, the government said, isn't this against your policy? Shouldn't this be taken down? And Facebook said, no, actually, it shouldn't. And so it's very different from the Vullo case, in which this was a totally ham-handed, clear, there was no doubt in this, right? I mean, the insurance regulator saying, hey, listen, don't do business with these people. Yeah. That was really straightforward. This isn't. And I don't think, maybe I'll say that reasonable people can, I don't even know I can say, to me, the case for standing is so weak here that I think that, again, there's a reason why 3 of the court's conservatives joined the court's 3 liberals in this. So this isn't you have your kind of 3, I would say, most far-right conservative activist judges who desperately wanted to take this case, just like you had that district judge who desperately wanted to come down on this issue and ignored all kind of, I think, standard notions of standing and judicial restraint because they wanted to make a policy impact. And I think that's wrong.
So, but let's get to, I guess, the government conduct. And
sure.
Then my question is, what do you think the remedy ought to be, if any?
Yeah.
For that? Because I think that's a significant question.
Absolutely. No question.
We run, to some extent, a media outlet.
Yeah.
And, if you were to start getting emails from the White House saying, listen, we really don't like what Jay said last week, you need to tell him to tone it down.
Oh, man, I'd run with that. Our numbers would shoot up.
You might be inclined to do that in the first place anyway.
Yeah.
But, and you said, well, all right, I'll look into it. And then you got another email the next week and you said, wait, Jay's still on. We told you to tone it down.
Now we told you.
What don't you understand?
And
then the next week, let me continue with this though.
Sure,
and, the president's press secretary, people are dying because of the stuff he's saying, and you're doing nothing about it. You have blood on your hands. That's, Jen Psaki's, words. Would you not feel pressure? And also, I should add then, well, look, we could probably, podcasts are probably covered by Section 230 and be ashamed if that went away. Be ashamed if the administration or the someone came in and decided to regulate your podcast.
Well, it would certainly be a much more credible threat to the podcast, but I think it's sort of like
it'd be pretty cool too to know.
Yeah, that's what I'm saying.
Really kind of attention,
really well for us. But I think there's an important distinction here, because for a threat to be credible, well, it has to be credible, right? If I say go up to The Rock and say, listen, you need to stop advertising your skincare line. I've seen he's got a skincare line. If you don't, I'm going to kick your ass. Well, The Rock would laugh at me. That's not a credible threat. Now, it's when you're talking about a company that has a over $1 trillion market cap, a huge, incredibly influential company, and the administration says, hey, Section 230, Facebook could say, yeah, you try to get the votes for that, buddy. I mean, I don't think it's much of a credible threat when we're talking about Facebook, certainly, or Meta, whatever you want to call it. So but that's part of the analysis. Is a threat that's not credible is not a threat. Coercion that cannot be carried out plausibly is not coercion.
No, I think that's probably a fair argument. But let's go back
to the. I was going to say,
let's say get the votes for it. That they say, all right, hey, we got a bill out there to repeal Section 230. Maybe you get the votes, maybe you don't. How much does Facebook have to spend to lobby against that?
Sure, and Facebook maybe takes the path of least resistance.
They already are.
Yeah.
Right. I mean, there already all are these. You see the ads all the time from the tech industry.
But let's go back to the area that
American
I think
innovation and so forth.
Let's go back to the area I think we maybe agree on a little bit more. And a previous question you asked is, well, what's the remedy? I'm saying that in this particular instance, this court case was not the remedy, and it would not have been appropriate for the court to take this case and rule that the federal government cannot engage in jawboning behind. And there's a difference between what Jen Psaki, whoever, says in public, right, and what happens behind the scenes. But I would say that you're right to raise this issue, and people on the right and the left in certain other instances who raise this issue are right to raise it. Well, what's the remedy for this sort of thing? The remedy is for this to be brought out in a transparent way and for voters to understand that this is what's going on, to hear this, and for them to make decisions about what sort of government, what sort of people they want in charge of their government. So in other words, the remedy is a democratic process, not some edict from the courts.
Right. Well, good. But how do you get that transparency?
By doing things like what Elon Musk did, releasing the emails and all that. I mean, transparency is transparency. That's how you get it.
So we'll just ask nicely, and they'll release the emails.
Well, what would you have? Would you have the courts just jump
you sue them and you seek them in discovery?
Well, there you go.
And then hopefully they release let me walk you through this. So there's another case brought by the same organization. In this case, they did have individual plaintiffs who had written, in this case, it was more Twitter than Meta, on various things that the administration took issue with. In this case, it was a lot of things calling into question shutdowns, right? And these were actual doctors and people with PhDs who were writing this. And again, maybe they're right, maybe they're wrong, but so they sued, and the government, this is the same government, the same defendants for the most part, said, you have absolutely no evidence. You have no evidence whatsoever that there was ever any communication between us and the social media companies. We want this case dismissed. The court says, yeah, I don't see anything here. They said, can we get discovery? No. Nope. We'd like to take a deposition. Nope. And they stonewalled, and they won. In this case, it was able to get through the discovery stage where they actually got some of these documents. And, that's a big deal, because otherwise this would never have come out. The government would continue to deny that these conversations ever took place.
Well, there's another way.
A lot of these documents also came through the fact that Elon Musk now owns X, formerly Twitter, because they were not giving up those documents before. And the government, if you look at how the government, its actions in Musk's purchase of Twitter, again, it's phenomenal. They did not want him to get that information. But there you go. And I think this ought to be really chilling to anyone. If you want to argue about standing fine, but again, I'd encourage people to go take a look at Judge Doty's opinion and the findings of fact in that opinion, and where so many of the emails are printed out verbatim, and ask if that doesn't trouble you or chill you and make you think, wow, the government really is trying to shut people up. And I guess that's our sense is, should the government be in the business of trying to shut people up? Well,
or another way to frame it is, should the government be in the business of trying to shut people up when they believe that there's the result of those people speaking is that a bunch of people are dying? That's a different question, but I think it's important.
Or that they're saying things like Hunter Biden's laptop is real.
I don't think we should. I don't think we should conflate these things. Let's stick one thing at a time here.
It's in the case. It's in the same. It's in Murphy versus Missouri.
Right, but I'm saying we're talking now. We're conflating a lot of things here, and I think it's important to pull these things apart.
But let me just walk you through it. I mean, the way it goes is, listen, someone's saying something terrible. They're saying the vaccines aren't any good. We have to do something about that. Okay, and you know what? Now they're saying other stuff, or no, they're saying COVID's a myth. They're saying COVID comes from China. That's no good. We can't have that. Now they're saying this laptop is real. That could hurt the election chances of Joe Biden, who is the only hope for democracy and health. So we have to shut that down as well. And this, you say slippery slope, but that's exactly the slope that the record shows here.
I think you're missing my point. My point is we actually agree on the importance of transparency here. We agree that when government is engaged in this sort of jawboning or coercion, wherever it goes into coercion, at some points it does, that should be something the public knows about. And I don't have a problem with the public knowing about that if it comes through someone filing suit to get that information out in discovery. There are other ways to do that. There are freedom of information requests. But I'm saying is that we agree on the importance of transparency, that people should know the sort of things their government is advocating, not just out in public, whatever Jen Psaki or the spokesperson saying, but maybe even more importantly, behind closed doors, the sort of influence that they are bringing to bear. We don't disagree on that.
Okay.
So there we go. We disagreed on we disagreed on a lot today.
But I guess where I come from is that the gravity of the problem shouldn't impact the constitutionality of the speech, right?
No, I don't think it should, but I'm saying that it is certainly, I don't have a problem with government urging companies to do things that will save lives, that are in the public interest, as long as they are transparent about the fact that they are doing so and that the public is made aware of those efforts.
But the whole point of these efforts is that they they did not make them publicly. They were private efforts. And I can remember thinking on the one case saying, well, look, they're never going to win this unless they can, pull out an email from the White House saying, please take down this post.
But those weren't the posts. To be clear,
it is.
The emails were along the lines of, we believe this is in violation of your guidelines. So therefore, how can this still be up if your guidelines on appropriate posts and misinformation say this particular post seems to us to violate that? Please explain yourself. I don't think that seems to me to be a reasonable thing. Now, I want to know about it, especially if it's a whole bunch of emails, but that doesn't seem to me to be beyond the pale.
Yeah, I would differ in the contents of the emails, and you can look those up. And any of the dissent in the case cites a lot of them.
Absolutely.
There's even more in the other cases below. So,
all right.
So I think, look, it's edifying reading, I think, for any American to see what's going on, and then to hear with the government saying, well, look, there's no evidence that we ever talked to any of these social media companies. This is all a right-wing conspiracy theory. No, it's not. These conversations are ongoing. This is pressure. I'm not sure what. Again, the federal government is pretty damn powerful, and the idea that maybe they couldn't get Section 230 repeal passed, so it's not a credible threat. There's a lot of other credible threats. There's a lot of other things the federal government can do. Consider the visit that the journalist.
I guess I don't know what you're saying, Jay. Here's the problem: as you keep on making the same point, but maybe I don't understand it. Are you saying that the federal government should not attempt to hold forth on issues of important policy, should not attempt to inform companies or to I don't know, pressure is maybe not the right word, but I guess I'm saying that shows. So if the federal government believes that an organization is doing something that, while legal, is not in the best interest of the American public, it should just stay silent. That's bizarre to me.
No.
What are you saying then? I know what you're saying.
It should not use its power as the federal government to lean on private organizations.
Well, I guess when you say use its power as the federal government, I think, again, there's an important distinction to be made between the sort of Vullo sort of thing, where that was clearly the case, at least I think that this seems fairly clear to me, and this, where I think it's a lot more questionable given the facts of the two.
I think that's our difference. Is I don't see that much daylight between Vullo and
Gotcha.
And,
okay, I see a ton. I see a galaxy between those two things. So yeah, I think you're right. That probably is where we part company.
All right.
Well, we'll stop on that. No, we did go fairly long, but I thought it was important to get that in because I knew it was something that we would have some pretty strong views on. And again, there are a bunch of things we didn't get a chance to talk about, a whole bunch of big Supreme Court decisions. We'll get to those in the midweek show, and we hope you join us for that. If you are a supporter, of course, you'll be getting that. If you're not a supporter, well, you get the first 10 or 15 minutes of it in kind of a preview kind of thing on Tuesday. But if you'd like to get the whole thing, we hope you do. You can become a supporter. We always put the links in our show notes there. So please check that out. You get the ad-free episodes, the Discord. The Discord has been just, wow, blew up yesterday, of course. All kinds of cool stuff. A lot of fun. Sometimes it just makes me want to pull out what hair I have left. But anyway, all kinds of good stuff, and we hope you will take a look at that. And if you do want to get that full midweek show and you're not in a position to support the show financially, send me an email, mike@politicsguys.com, and I will get that set up for you. And whether you're a supporter or not, it really matters a lot if you rate, review, and share episodes with folks. So please do that. We really would appreciate it. And finally, as always, a very special thanks to our fantastic executive producers, Bruce Johnson, Wilma Moreno, Daniel Toe, Ryan Beasley, and Don Oglesby. We'll be back with a new episode for you next week. We hope you'll join us.
This podcast is part of the Democracy Group,